You're pulled over by the police and they ask you, have you been drinking? Had anything to drink tonight? And you're wondering how you're supposed to respond to that question. We in Canada have this urge to answer honestly when we're asked a question. It's a peer pressure thing and maybe part of our Canadian DNA. But in many circumstances, particularly if you have been drinking, it's not wise to answer the question with anything that confirms anything or denies anything. So any answer that you give ultimately can be used against you. In the administrative context, it's used against you to challenge your credibility, or basically to remove your credibility. Because if you were to deny consumption and then you blow into a roadside breath tester and there's some alcohol there, then of course you come across as a liar. So you damage your credibility right there. In the criminal context, the results of that approved screening device test are only used to elevate the police officer's opinion to reasonable and probable grounds that you committed an offense. But that discussion inevitably ends up, coming out in some form or another, and again, damages your credibility. If not before the court, then before the prosecutor who's looking at the file and making decisions, and your lawyer's trying to, deal with that prosecutor. So the smartest thing you can say is nothing. But you're sitting there thinking to yourself, if I say nothing, if I just sit here, silently when they ask the question, mouth closed, I'm going to look like a real weirdo, and that's going to be very suspicious. Well, assume you can't talk your way out of it. I'd rather you look like a weirdo, frankly. But there are things you can say. The problem is that, the police officer's measuring your speech. The police officer is looking at you hyper suspicious no matter what, because that just seems to be the way so many of them are, sort of paranoid or suspicious of everybody at all times. So if you are going to say something, you want to limit the number of words so they have as little as possible to describe your manner of speech. So you could say something along the line of, I don't talk to cops. You can say, I believe in my right to silence. And you could say, lawyer told me not to talk to you, which is my trademark phrase, and feel free to use it because I'm the lawyer who told you not to talk to the police. If you say any of those things, many police officers, especially police officers that have been around for a while, will get it. And they may, do their next steps of their investigation. But the point is, your credibility can't be impugned by something that is, in those circumstances indicates that you're relying on your right to silence. Now, after that, what's likely to happen? In Canada, the police can demand that you provide a sample into a roadside breath tester, regardless of whether or not you answered the question in the affirmative or denied it or didn't answer the question at all, as I would suggest you do by not answering in those three different methods. They can still make a mandatory demand, a demand that you are required to provide a sample into a roadside breath tester. And if that happens, then of course you have to provide a sample. And in every province, there's some form of legislation that requires you to present your driver's license to the police and confirm who you are. In BC, we call it the Shriver's test, but it's actually written into the Motor Vehicle Act. You have to confirm your name and your address, not your date of birth, interestingly, although many police officers seem to think that you have to confirm that. And you're required to provide a sample, a genuine attempts to provide a sample into that roadside breath tester until they can get a sample that is suitable for analysis. Now, they may ask you a bunch of other questions after they've made the demand, and these are really subject suitability questions. They're questions about whether or not you are a suitable candidate for testing at that point, or whether or not they should delay testing. And in that case, absolutely, if you've been subject to that demand, do not answer any of those questions. That's when you just absolutely keep your mouth shut. Because again, if you were to say, I had one beer, and it was an hour ago, and you provide a sample that's a fail, well, obviously you didn't have one beer, or there's some other issue that's taking place. But if you say that it was an hour ago, you've just answered so many of the questions that they would need to be able to prosecute you, to use that against you. So your best bet is to not answer any of the subject suitability questions. Have you had anything to drink in the last 15 minutes? Keep your mouth shut. You had anything in your mouth in the last 5 minutes? Keep your mouth shut. Do you smoke? Do you vape? Keep your mouth shut. Don't say anything. Just keep your mouth shut in those circumstances. Or again, you can always lawyer told me not to talk to you, but at this point you shouldn't have to say anything. Hopefully the police officer gets it, that you are not a chatty Cathy, you're a very quiet person there, and you understand your rights. Keep your mouth shut, don't say anything when you're pulled over, and if they ask you if you had something to drink tonight, do not answer that question with a responsive answer. Just indicate that you are not talking to them about anything like that, and you're likely to be in a better position down the road. What you have to anticipate or understand is we as lawyers are looking at it assuming that you're not going to be able to talk your way out of it, because nobody does, because the roadside breath tester is ultimately going to be the thing that is used to decide what's going to happen next. So assuming you're not going to be able to talk your way out of it, people can't, okay, in those circumstances. What we're trying to do then is we are thinking about what is going to end up in front of the court or tribunal, and we are considering what evidence that they're going to have to use against you. And we'd like you to be in a better position, because it could be an unreliable test. It could not be reflective of your blood alcohol concentration for so many reasons, but we want to make sure that you've got those defenses. And when you talk, you basically dump our tools out of our toolbox. Imagine you show up at a job site and the only tool you've got is a hammer, and you need a saw, and you need a screwdriver, and you need all sorts of other things. When you talk to the police and start filling the case in for them, basically you're sending us to the job site without any tools. But if you maintain your right to silence, don't discuss anything about don't answer their questions except confirming who you are, then you fill our toolbox with all sorts of tools that we can use to defend you. So, strategically here, the reason that we're telling you to maintain the right to silence and to just indicate to the police that you're not answering any of those questions or talking to them is because we want to make sure that you are giving us the tools we need to be able to get you the best result in your case. And it can be, in cases where there's negotiation, like criminal prosecutions, it can be a situation where you've filled our toolbox and we're able to negotiate something much better for you that mitigates the damage for you. And again, this is one of those things that we are looking at, thinking down the road, how it would play out in court. And so is a prosecutor looking at it, how it would play out in court. And they're looking at their file and they're going, this is a really meaty file. We've got a good one. This guy was chatting the whole time. He was talking to the cops and made all these admissions. And we're looking at it going, man, there's no tools in our toolbox to try and negotiate something out. But then we've got those circumstances where people were silent the entire time. And we're looking at it going, hey, this is not so bad, Mr. Prosecutor, Madam Prosecutor. Maybe you should be considering resolving this with something that's a little bit fairer for our client, a better resolution for our client. Because, in fact, we've got a pretty good case and you don't have that strong of a case. So that's why we're thinking about it. So that's the reason that we're encouraging you to keep your mouth shut, to rely on your right to silence, to not answer those questions with responsive answers, but only with answers that indicate that you're not answering, right? Like, lawyer told me not to talk to you. Lawyer told me not to talk to you.